I would like to share with you about the parties that are allowed to sign a contract. In our previous session, we did look at all the clauses that had to be filled in. So this is just for the buyers and sellers are allowed to be signing an offer. And I got the information from STTB, which is a law attorney firm that offer fantastic information, brochures, and training. The following entities can be parties to an agreement of sale of immovable properties. Minors under 18 years of age, not everybody knows this. I'm going to go into it in more depth a bit later. Unmarried men or women, married men or women, companies, closed corporations, companies to be formed, partnerships and trusts. You cannot have a trust to be formed that signs an offer to purchase. If they don't have their IT number ready, they must sign in their personal capacity and at a later stage change it to a trust, but with an addendum. But remember, then make sure that the bond wasn't applied for in a personal capacity. So make sure that you have this correct, but it can be a company to be formed, but not trust. Married in community of property, that's including civil unions. Both parties have to sign the agreement. Married out of community of property, also including civil unions, only the spouse that is buying or selling must sign. If both parties want to purchase or sell the property, then both have to sign. So if they say that they are married out of community of property and the husband wants to sign, but his wife also has to be included in the bond, then both have to sign, because whatever is on your contract must be on your bond application. Okay. In divorce, if the spouses are in the process of getting divorced and divorce has not been finalized yet, then both spouses will have to sign the offer to purchase, irrespective of whether only one spouse will be awarded the property after the divorce has been finalized. So once it's been finalized, then the spouses who is awarded, are awarded the property may sign the offer to purchase. Sorry, I didn't see there's a grammar error there. Okay, this is quite interesting. Religious marriages, Hindu, Islamic, or Muslim, because the Matrimonial Property Act does not apply, the spouse does not need to consent to buying or selling a property. However, if both spouses want to buy the property, like I said earlier on, without a community of property, then they both want to apply for instance for a bond, then both will have to sign. But it's interesting one is that they do not need consent. If both own the property, then both of them have to sign when selling. Okay. On a customary marriage, on 15th of November 2000, it became known as a civil marriage. The wife has the legal capacity to contract and does not need the consent from her husband to sign the offer to purchase when selling or buying. So this is very similar to religious marriages. If both want to buy the property, then both will have to sign. If both are the owners of the property, then both will have to sign when selling. In polygamous marriages entered into before the 15th of 11/2000, both parties have to sign the offer to purchase. I always will say that if you are not sure, let both sign. But it's a very good thing just to check before you go and to do an offer to purchase. Always have this handy so that you can have a quick reference to it, and you can also show it to your clients if they are not aware of the situations. If there's a death of a spouse, when selling a house out of the estate of a deceased, the offer to purchase will have to be signed by the executor of the estate or ratified by the executor of the estate. Always be sure to consult with the executor of the estate. Make sure that you speak to them and you know that you have the correct person to sign. These transactions always obviously take longer as well. Companies, trusts, closed corporations, when buying or selling a property, the authorized representative needs to sign the offer to purchase. The agent has to obtain a resolution, and I think that will answer one of the agents. Tina's asked me last week on the mandate. This answers that question as well. that he has to have a resolution by all the trustees and directors, which will indicate who is authorized to sign the offer to purchase. This is also valid when it gets to a mandate. On minors, children under the age of 7 have no contractual capacity. A natural or legal guardian will have to contract on their behalf and sign the offer to purchase. But interesting, a minor under 18 but older than 7 would have to be assisted by a legal guardian in order to conclude a valid contract. The guardian and the minor must sign the offer to purchase. So under 7, only the guardian or the person that's signing on behalf of them, the parents, but between 7 and 18. Older than 7, so from 8 onwards to 18, the guardian and the minor can sign together. Foreign marriage, when signing an offer to purchase where the buyers are married according to the foreign law, it will depend on the country's law, or on the law of that country. To be sure to secure your sale, to let them both sign the offer to purchase. Make sure they both sign if you're not sure. It's always rather too many signatures than too few. I just thought that this is quite a handy thing to have with you. So when you sign, that you know exactly who must sign. We don't very often have minors, but it can happen.